Hi, this is Scott Horton. I will be presenting today's webinar. We have just opened up the room for attendees to join, so we will allow time for that to happen, and then we will be getting started in just a few minutes. Again, thank you for joining us today. We will leave a couple more minutes for everyone to get logged in, and then we will get going with the presentation as scheduled. As you log in, you should hopefully be able to hear my voice. If you can't, then the rest of what I'm about to say is irrelevant, but assuming you can hear me, you should also be able to see the cover slide for today's presentation, Hero Act Update Part 1. And you should have access to a chat room, which is where you'll be able to type in questions that you may have to be answered primarily at the end of the presentation. I'm just going to allow another couple minutes for everyone to get logged in. In the meantime, thank you for attending, and we will get started as scheduled. We have very good attendance for today's webinar. Obviously, a very pressing topic, and we're just going to allow enough time to let everyone who is available to be here at the start to get logged in and situated. So another minute or two, and then we will get started with the presentation. Okay, I'm just going to give about another 30 seconds to let anyone who is trying to get logged in to do so. Then I will begin with sort of the preliminary technical issues, and then we will get started with the content. Okay, hello everyone. My name is Scott Horton. I'm an attorney with Horton Law PLLC. My office is in Orchard Park, New York. We present a series of webinars approximately every month on pressing topics of interest to employers. And today's topic is one that is of interest to New York employers, which really means any employer with at least one employee in New York, with the caveat that these requirements only directly apply to private sector employers. So if you're a public employer, some sort of government entity, a city, a town, a village, a county, or a public authority, then this law is probably not going to apply to you unless that is you move to another position with a private sector employer. But if you are not a government entity, whether you are for-profit, not-for-profit, publicly traded, privately held, etc., and have at least one employee in New York State, then this topic is relevant to you and action is likely required within the next couple of weeks. So before I get into the presentation specifically, I just want to note that I will be making the slides available at the end of the presentation. If you don't want to wait for whatever reason to get them then, if you're registered for the webinar, you will get an email tomorrow with a link to the slides. I will take questions, use the chat feature to type those in as you have them. For the most part, I will wait and do a question and answer at the end to answer the questions rather than stopping as I'm going. But if I happen to see a question that I can answer in the midst of the presentation, then I will do so. Most importantly, I don't want you to forget your question. Keep in mind when you're asking questions that this is not a confidential setting, so don't ask something that requires attorney-client confidentiality and privilege. If you have that type of question and you are my client or need to become my client, then please contact me outside of the webinar. With that, we're going to get started on the HERO Act update part one, because I certainly anticipate at least a part two and potentially more segments. But part one here specifically is focused on the airborne infectious disease prevention requirements under the HERO Act. There's a separate component of the HERO Act regarding workplace safety committees, which I will mention in a couple of relevant respects, but which I anticipate being the subject of a subsequent webinar once we have more guidance from New York State, and those requirements don't take effect until November 1st. And as we will discuss, the aspects of the HERO Act relating to airborne infectious disease prevention take effect much sooner. So generally, the Health and Essential Rights, or HERO Act, was signed by Governor Cuomo on May 5th, and then based on comments that the governor had when he initially approved the legislation, was amended on June 11th. So as soon as it was approved on May 5th, we knew there were going to be amendments coming pretty quickly. Those did come in June, and now we know what the law requires in the sense of what the statute says, but we've been waiting for additional guidance, primarily from the New York State Department of Labor. Because the HERO Act does amend two sections of the New York labor law, over which the Department of Labor has the authority to issue guidance, rules, and regulations. Both of these aspects of the HERO Act apply to private businesses, as I mentioned, both profit and for-profit alike. They just exclude governmental agencies. The first section of the labor law addressed by the HERO Act is a new section 218B that addresses airborne infectious disease exposure prevention, and that is going to be the focus of the presentation today. The primary requirement of this section of the labor law is that covered employers must adopt an airborne infectious disease exposure prevention plan. Then by implication, they must follow the plan, and they may not retaliate against employees who complain that they are not following the plan. As required by the statute itself, the New York State Department of Labor did issue a standard and model plans on July 6th. The result of that timing is that now employers must adopt their own plans. That is, say, they have to adopt an airborne infectious disease exposure prevention plan by August 5th, which is coming up in roughly 2 weeks. The penalty for not having a plan in place is at least a fine of at least $50 per day that the plan is not in place after August 5th. And if for some reason you are deemed to have not had a plan in place and fined, and then still don't get a plan in place, subsequent violations have fines of at least $200 per day. But we don't really know what the extreme of that is, because it just says fines of at least $50 and $200 per day, potentially allowing the Department of Labor to impose higher fines. So we've generally talked about what covered employers means. We also should address covered employees, because under the new section of the labor law, this is a broader term than the normal definition of employee. Fundamentally, for example, it includes independent contractors. That does not mean that everyone who has historically been an independent contractor is now an employee for all purposes of New York's labor law, but it does mean for the protections provided by Section 218B with respect to airborne infectious disease exposure prevention, employers owe obligations not only to their traditional employees, but to also independent contractors, among other categories of employees that are specifically spelled out in the Act, such as temporary, part-time employees, etc. So anybody providing work for the company on a work site operated by the company is going to be protected under the safety plan and the retaliation provisions that go along with the law. The one interesting caveat at the moment is that it seems that certain healthcare workers are not covered, and by extension, arguably, the employers of healthcare workers, hospitals, for example, are not currently required to have these plans in place. Now, this is not clearly stated anywhere in the law or arguably even by the Department of Labor at this point. What we do have is a statement in the new standard provided by the Department of Labor that says that the standard does not apply to any employee within the coverage of a temporary or permanent standard adopted by the Occupational Safety and Health Administration, meaning the federal OSHA, setting forth applicable standards regarding COVID-19 and/or airborne infectious agents and diseases. Relatively recently, OSHA did finally issue an emergency temporary standard applicable to the healthcare industry. So by extension, it appears that the Department of Labor is saying, the New York Department of Labor, that is saying that healthcare workers are not currently subject to the state requirement because they are or may be subject to a federal requirement. There is more complexity to that because not everybody who would generally be considered a healthcare worker is covered by the OSHA standard at this point in time. There's a flow chart available from the OSHA website that walks you through trying to figure out whether your employees qualify, and it's not just based on the type of work that they perform. It's also based on the environment in which they perform it, and it's also a relevant factor whether and the extent to which the workforce is vaccinated from COVID-19. All that by further stating that it doesn't mean that if you're in the healthcare field, you can now log out and stop paying attention to this presentation, because again, remember, that is an emergency temporary standard specific to COVID-19, and the New York law is not limited to COVID-19, and potentially in the future, that emergency temporary standard from OSHA will be withdrawn, and or there could be a future disease that OSHA has not immediately covered, at which point in time even healthcare workers and their employers would be obligated to comply with the state law. If you're in that field, I recommend that you work with your counsel to decide what your obligations are at this immediate point in time, whether you need to have a plan in place, etc. I mentioned before, you will get copies of the slides at the end, or if you're registered by email tomorrow. So I saw that question. If you logged in late, just so everybody knows, you're not trying to frantically write down everything that I'm saying. Another piece of evidence from the New York Department of Labor, beyond the general reference to OSHA standards, is the fact that in the specific industry templates that they provided, model plans based on industry, which they were required to provide by law, there is no healthcare specific plan. It seems likely that if they were not deferring to OSHA's standard, there would have been a healthcare specific industry template. Again, that doesn't mean there won't be a healthcare industry template at some point in time. But at the moment, these are the industries that have a specific template plan: agriculture, construction, delivery services, domestic workers, emergency response, food services, manufacturing and industry, personal services, private education, private transportation, and retail. The general plan would then apply to any employer that doesn't fit into one of these categories. Frankly, there is not a tremendous amount of difference between the general plan and these specific plans. In fact, some of the distinctions come down to purely typographical differences. Something is bolded or capitalized in one, but not the other, or there are literally typos, extra commas, or spaces in the general plan versus one of the specific industry plans. But there are a few areas where they add some specific detail in some of the industry plans. I'm not going to go through all of those distinctions, but you can review the plan that's most applicable to your industry. But I will, by example, show a couple of the areas where specific industries differ from the general plan, really just by way of showing that these are not highly specific plans for any of these industries. They're pretty vague and generic across the board. Just to make sure everybody's paying attention and awake, I just wanted to have a quick question that I'm going to throw up that you can click to answer to give me a general idea, and we can all get an idea of whether you feel any of these plans clearly apply to your industry, your company. So some of the options include, yes, we know one of these plans applies, or yes, we think we're under the model plan, or for some of you, it might be that you're in a gray area. And finally, I added the category of, well, we might be healthcare, so we're not really sure. So I'm just going to allow another few seconds for some responses to come in. Don't see any, but oh, there we just got a healthcare. For the most part, about half of you, it looks like, are pretty comfortably finding yourselves in one of these industries. Maybe 20% say we're in the model plan. So between that, we're looking at about 3/5 of you feel comfortable with which plan applies to you. Another about quarter of you are in some sort of gray area where either you have operations in multiple industries or you're not really sure whether one of these specific templates apply to you. And then we've got 10% saying they're in the healthcare category. So thanks for providing that insight. I will note that these industry templates don't try to define the industry. There is more guidance in the COVID-19 safety plans from the various industries that kind of talk more about what the industry includes. For example, personal services included things like barbershops and nail salons and hair salons. But again, there's no guidance in these specific industry templates at this point in time. So now I'm just going to kind of generally walk through the different aspects of the model plans. And again, I'm going to reference the general plan primarily, but you can quickly tell by looking at any of the industry specific plans that they're all set up essentially the same way. They just have a few more basically examples of some of the specific controls you might put in place in case of an outbreak. So the first section is actually an introduction that just says generally what the HERO Act is all about with respect to requiring these plans and explaining which employees are protected, that goes beyond traditional employees to include independent contractors. There's also a reference there to please check the websites of the Department of Health and Labor to get an update on whether a designation has been put into effect. So you have to adopt the plan by August 5th, But that does not mean that the plan is in effect. Currently in New York, the COVID outbreak has subsided, or at least the state of emergency has been lifted, and the Commissioner of Health has not designated COVID as a qualifying disease outbreak to trigger the effectiveness of these model airborne infectious disease exposure prevention plans. So you'll have to get the plan in place, but at present it is not active per se. What you do need to do in adopting these plans is to identify which work sites are subject to the plan, which may be all of your work sites or maybe specific work sites if you have different plans for different work sites. And you need to designate supervisory employees who will enforce plan compliance. Now, it's probably not for most of you an issue that it has to be supervisory employees, but the statute itself and the guidance from the Department of Labor makes it abundantly clear that these have to be supervisory employees. You cannot put non-supervisory employees in the position of being responsible for enforcing and ensuring compliance with these plans. So here's literally cut and paste from the prevention plans showing how you can fill this information in. The plan applies to all employees of, put the name of the company, and all the following work sites. So either all the work sites or you list the specific work sites. You then put below name and contact information for people who are responsible for enforcing compliance with the plan. The next aspect of these plans is a category called exposure controls during a designated outbreak, which is further broken down into a few different categories of controls. The first of these is called minimum controls during an outbreak. And then it lists these, I believe it's 9 different categories. Most of these are not very long. There's a couple sentences for each of these different components of the minimum controls. These are all components that are required ultimately by the statute, so the Department of Labor has pushed them through to these template plans. For example, the general awareness just says that employees should remember to maintain physical distance, exercise coughing, sneezing etiquette, wear face coverings, limit what they touch. Really, it's just going to be general awareness of these other items on the list. Stay-at-home policy refers to the statement that if an employee develops symptoms of the infectious disease, the employee should not be in the workplace. Employees should inform the designated contact and follow Department of Health or CDC guidance. So these are not intended in the model plan to be specific. They are just rather general statements on each of these topics. Similarly, for things like house screening and face covering. So there's really not that much new detail in here. There's probably less detail in a lot of respects than we saw in the COVID-19 safety plan templates or standards that came out earlier in the pandemic. Most of these items don't require anything other than what's already pre-written into the model plans. The one exception is this section on physical distancing, where it references maintaining a distance of at least 6 feet, or as recommended by the Department of Health or CDC for the infectious agent. This by way of reminder that this is certainly all based on COVID, but again, does not immediately even apply to COVID. And it's all intended to apply to some future disease outbreak and recognizes that whatever the right methods of avoiding transmission of COVID were, there might be different standards for future infectious diseases. Perhaps 6 feet becomes too close together, or a wider distance than required for the future infectious disease. But the kind of interesting component of this part of the plan is it asks the employer to check off the controls that they intend to use and add any additional controls. So again, I think in one respect that's a little challenging, that you're supposed to know which controls you're going to use in the event of some future disease, that you don't necessarily know how that particular disease is going to operate and what is going to be effective in preventing transmission of that disease. But this is what the model plan asks you to do at this point in time. So then we follow the minimum controls with a section called advanced controls during an outbreak. And these fall into these four categories: elimination, engineering controls, administrative controls, and PPE. Elimination is a specific term used in the Department of Labor templates. What it goes on to be defined as is one sentence: employers should consider the temporary suspension or elimination of risky activities where adequate controls could not provide sufficient protection for employees. The longer components of the plan are the next couple: engineering controls and administrative controls, and we will go into that in more detail on the next slides. So engineering controls primarily include different categories of ventilation, being mechanical ventilation, general ventilation, and natural ventilation. Mechanical ventilation talks about local exhaust ventilation, so kitchen vents, ventilated booth, lab hoods, that sort of thing. General ventilation talks about your overall ventilation of the building or work site, references introducing fresh air into air handling systems, avoiding air recirculation, using higher efficiency air filters, that sort of thing. Natural ventilation refers more basically to opening doors and windows to create natural airflow, and being careful with how you open windows and use exhaust fans so you don't blow air from one individual to another and risk contamination and transmission that way. The engineering controls also refer to automatic disinfection systems such as ultraviolet light disinfection, installing cleanable barriers like sneeze and cough guards or barriers between workstations, and changing the layout of your premises to avoid congregation of employees, where an example given is installing additional time clocks. So frankly, what I just described is about the extent of what the template plans say on advanced controls. They don't get specific. There are not detailed standards on what you must do or may not do. By way of example, this is an area where the manufacturing industry uses more specific, in some respect, examples. It suggests that companies use air filters with MERV 13 or higher. And if that's not possible, it just says to use the highest filter compatible with your HVAC system. So again, it's not a standard in the sense that you're obligated per se to do something specific to be in compliance. It just says that you should consider having basically the best air filter that you can handle. You can consider air purifiers. It even gets down to suggestions like adding time clocks so that employees don't have to wait in line to clock in, and spreading out workstations, including along assembly lines. Again, there are no specific requirements for how this has to be done, and following the template plans, it's not even clear whether the Department of Labor is requiring employers to go into much more detail. The way these plans are written, it just lists these different components as examples. And then with respect to engineering controls and other types of controls, has a box like this that says subject to changes based on operations and circumstances surrounding the infectious disease. Engineering controls that are anticipated to be used are listed in the following table. Again, there is no further guidance at this point in time on how specific this has to be, and there's not a tremendous amount of space provided in these template plans, which perhaps suggests that it doesn't need to be very specific, which perhaps is based on the understanding that whatever the actual methods to be used in any specific outbreak will depend on the nature of the disease, to the extent there is information then known about the disease and how it is transmitted. The next component is administrative controls, which lists examples such as the following: increasing space between workers, providing training of employees, prioritizing certain job functions so that you can reduce the head count in the building, putting up appropriate signage, allowing additional breaks for hand hygiene and cleaning of surfaces, and using pods or cohorting or other methods of avoiding interchange between employee groups where possible. So again, this is just a list of examples in the plan, and then as there was for engineering controls, there's a similar box where they would have you spell out again the ones that you anticipate using in your workplace. This is a different example for administrative controls. The food service industry has some further suggestions, such as prohibiting eating and drinking in the work area, limiting or discouraging handling of cash, not refilling cups that have been used, letting diners pack their own to-go boxes, and developing touchless curbside pickup. To be clear, my reading is not that any or all of these are required. It's just, again, that they're listed as examples of things that companies in the food service industry might consider as part of what they will do in the event of an outbreak. And I know there are good questions coming in. I appreciate that. Just keep typing them in as you go. I will stay on and answer all of the questions that come in at the end of the presentation, but I just want to get through as much of the presentation as possible, or get through the presentation as efficiently as possible for those who need the information and maybe can't stay at the end. There's a housekeeping section. I'm sorry, I skipped over. There's a PPE section too, but it just basically says PPE are devices like eye protection, face shields, respirators, and gloves. And then there's a small box to identify what types of PPE you will have on hand and where they will be located. Then there is a housekeeping component to the plans, as I said, that is limited in what it addresses. It only takes up a little more than half a page in these categories: disinfection methods and schedules, adjustments to normal housekeeping procedures, isolating symptomatic employees, and honestly, one of the 4 categories in housekeeping comes down to trash can procedures, where it says, for example, in particular, that whole point says, as feasible, liners should be used in trash containers. Empty the containers often enough to prevent overfilling. Do not forcefully squeeze the air out of the trash bags before tying them closed. Trash containers may contain soiled tissue or face coverings. In some respects, that is about the most specific guidance provided in any of these model plans. Most everything else is listed as examples and suggests the employer should identify what they're thinking they might do among those examples without much direction on what you have to do or how far you should go. The following section after that is called Infectious Response during a designated outbreak, and that entire section consists of what you see on the screen. Just says if an actual or suspected infectious disease case occurs at work, take the following actions. Instruct the sick individual to wear a face covering and leave the work site, and follow New York State Department of Health and CDC guidance. Follow local and state authority guidance to inform impacted individuals. So there's nowhere near the type of detail that was in the standards that applied during the COVID pandemic for different industries, or generally as to whom to contact and when people can return to work and all of that. Again, likely recognizing that any future disease outbreak will have parameters specific to that disease. Then there is a training and information section, and this one creates a couple of ambiguities and potential headaches for employers, in my opinion. There is generally a requirement that employers will verbally inform all employees of the existence and locations of this plan, the circumstances it can be activated, the infectious disease standard, employer policies, and employee rights under the HERO Act. Notably, employee rights under the HERO Act would also include the rights regarding the Workplace Safety Committee provisions of the HERO Act that are an entirely different part of the labor law from the airborne infectious disease exposure prevention requirements. So it is a little questionable whether this is actually a requirement under the airborne infectious disease exposure prevention plans. But the bigger question with all of this is whether this is training that has to be done now, for example, or when you adopt the plan, or at some other time. Clearly, and the law makes it clear, there has to be a verbal review of some of these types of issues when the plan gets activated, i.e. when an outbreak has been designated. But given that there's not currently an outbreak in place, at least not one that's been designated by the Department of Health as requiring the activation of such plans, it is arguable whether you need to do any training at this time. After that general statement, there's a separate component of these model plans that says when this plan is activated, all personnel will receive training, which will cover all elements of this plan and additional following topics that are specific to the nature of the disease involved at that time. I think it's a fair reading of these model plans that they expect training before there's even an activation. So arguably when you adopt and put in place the plans, there's an expectation, or at least the plan suggests there's an expectation of training at that point in time. I'd say the separate standard document that came out from the Department of Labor does not imply that there have to be any training until plans are activated. And that is based on language from the statute itself, which again, I would say is best read to not require any training, or actually verbal review is the phrase used in the law itself, until there's activation of your plan. So that is something you should consider. Not to say it wouldn't be a best practice to go ahead and do some training when you roll out the plan, but it is debatable at least whether you're obligated to do so, other than the fact that if you're using the model plan on its face, it seems to imply that there is going to be training even before there is activation of the plan. Meaning even before there's some outbreak of an airborne infectious disease declared by the Commissioner of Health. Where you have training, the model plan states that it must be appropriate in content and vocabulary to your educational level, literacy, and preferred language. It says your, I'm reading that to mean that it's referring to the employees as you. So your training has to be appropriate in content and vocabulary to the employee's educational level, literacy, and preferred language. That is actually a fairly unique assertion from the Department of Labor. I don't think we've seen that exactly in any other training requirement. The preferred language is similar to what is required in the sexual harassment training that's required under the labor law. But trying to determine what each of your employees' educational level and literacy require by way of content and vocabulary sounds like a challenge for some of you, and arguably means that you have to do your training differently for different categories of employees. But that is a component of these model plans, although not necessarily one that tracks through to the law itself, other than with respect to the language. Not to say you wouldn't want your employees to understand the training. It's just a question of, could you be taken to task for not satisfying this component if somebody were to come forward and say that this training wasn't appropriate to my educational level. The next to last aspect of the model plans is a section called Plan Evaluations during a designated outbreak, which says the employer will review and revise the plan periodically upon activation of the plan and as often as needed to keep up to date with current requirements, and then provides a table for documenting plan revisions. The table says plan revision history, then has columns for date, participants, major changes, and approved by. So clearly understand your plan is going to change, and try to provide a blank for, or not a blank, but a chart for that to be referenced. I don't know if you change your plan entirely, do you still have to have that chart showing all the previous changes? None of this is specifically required by law, and we don't have any guidance on or instructions, for example, from the Department of Labor at this point on how to use these templates. The final component of the plans as required by law is called Retaliation, Protections, and Reporting of Any Violations. This states that no one may retaliate against any covered employee, which again includes independent contractors, for exercising their rights under the plan. It protects employees for refusing to work based on a good faith belief of an unreasonable risk of exposure after the employee has given notice of that belief to the employer. And the section in the template plans kind of implies that actually states that employers should include contact information for reporting violations. Interestingly, though, there's no space for that to be included. There's not a chart like there was. Maybe just putting in the responsible supervisors in the first section satisfies that component. I think it certainly opens the door that if at the end you wanted to add in a specific statement of if you have any concerns of retaliation or whatever, then this is who you contact. But again, it's a little surprising there's not just a blank for that, considering the way they put together the rest of the document. Okay, so that was a lot of the ins and outs and details of what is in these template plans. And now I'm going to get into a little bit more of the strategy and options and considerations for the last portion of this before we get into your questions and answers. So you do have options at this point. You can either adopt the model plan, the template industry plan that applies to you, or the general plan if there's not an industry specific plan. Or you can pursue using an alternate plan. The catch with trying to use an alternative to the templates is that the statute itself requires that in order to do that, if you have a union, you have to reach agreement with the union on the alternate plan, or if you're non-union, you still can only implement an alternative plan with, quote, meaningful participation of employees. Clearly, employees here is not intended to mean supervisory employees, or at least not limited to supervisory employees. What meaningful participation of employees is anyone's guess at this point. We do know the HERO Act included not only these requirements, but the Workplace Safety Committee idea. So when that goes into effect, presumably your Workplace Safety Committee could get involved, and that may constitute meaningful participation of employees. But really, this whole concept of using an alternative plan is something that it would be nice for the Department of Labor to address with further guidance or regulations. And so far, they have not commented on that. So whether you can get the union to agree to an alternative plan by August 5th is a fair question. Whether you can figure out whether you've had meaningful participation of employees in the non-union context is a question. And, you know, all of those factors kind of push towards using the model plan if you possibly can. Again, there might be reasons not to, but certainly weighs in that direction as nothing else an administrative convenience. The law also says that any alternative plan must be tailored and specific to hazards in the specific industry and work sites of the employer. It's fair enough to say that for the most part, even the industry-specific template plans from the Department of Labor are not very well tailored and specific to hazards in the specific industry and work sites of the employer, or at least they're very generally tailored rather than carefully tailored. So you may be imposing a higher bar on your plan by trying to use an alternate to the model plan templates. The timing issues that you again need to be aware of, again, I've mentioned it several times, the plan has to be adopted per se by August 5th and posted prominently in each work site, which typically would mean where your other employee rights posters are put up. There is language in the statute that talks about work sites, including vehicles, but you're not required to post this in the plan in each vehicle. But any building or construction site, for example, you would be expected to have your plan posted, presumably by August 5th. Once you adopt your plan, you have to provide it in writing to all existing employees within 30 days. So you don't have to do that by August 5th. You would by September 4th. Thereafter, any new hires have to get a copy of the plan in their new hire paperwork. And if you have an employee handbook, you have to include the plan there. I don't think the law is clear enough on when that has to be done, but there's an argument that that would need to be done by August 5th. On the other hand, there's an argument that you shouldn't have to do that until 30 days after you adopt the plan, as late as September 4th, because that's when the law otherwise requires you to provide the written notice to all employees. So most critical, have a plan adopted and posted by August 5th, and then get it out to your employees within the next 30 days. The way the law is written, if you were to adopt the plan today, for example, then you would need to get the plan out to your employees within 30 days from today. You wouldn't have all the way up until September 4th. That might be a factor in when you adopt the plan, independent of when you have the plan finalized. Now, to bring a couple of points together in my last slide, I need to review again a little bit about the Workplace Safety Committee component of the HERO Act. This is a separate provision of the labor law. As I mentioned, it's section 27D. It applies to private employers with at least 10 employees in New York. So a few of you may have caught a break on that one because either you're under 10 employees overall or most of your employees are outside of New York. But if you have 10 employees at a work site in New York, then you are going to be subject to the workplace safety committee requirements of Section 27D. Frankly, though, we don't quite know what that requirement is at this point. The law says that the covered employers must permit employees to establish and administer a joint labor management workplace safety committee, but we're not entirely sure how the Department of Labor is going to interpret that permit concept. Does that mean that all employers with at least 10 employees have to form somehow one of these workplace safety committees, or does it just mean if some employee wants to have a safety committee, then they get to have one? Or does it mean there has to be some majority support among employees to invoke the right to have a workplace safety committee? Hopefully these answers will be provided by the Department of Labor. They may not be the right answers. They may not be the answers that anybody likes, but at least hopefully there will be answers so that we have something better to go by beginning November 1st when this portion of the law takes effect. All of this is potentially relevant to this airborne infectious disease exposure prevention plan business that we've been talking about, because among the activities that the Workplace Safety Committee is entitled to participate in are, for example, reviewing any policy put in place in the workplace required by the New York labor law relating to occupational safety and health, which would certainly include the Airborne Infectious Disease Exposure Prevention Plan, and providing feedback to such policy in a manner consistent with any provision of law. Again, you could debate what that means. You could also debate whether this applies to plans that are then already in place, as your Airborne Infectious Disease Exposure Prevention Plan will be before November 1st. The next bullet that the law allows these committees to do is review the adoption of any policy in the workplace in response to any health or safety law, ordinance, rule, regulation, executive order, or other related directives. So does that mean once a policy's already been adopted, if it was before November 1st, it's too late for the safety committee? I think one way or the other, at a bare minimum, any future revisions to your Airborne Infectious Disease Exposure Prevention Plan after there's a workplace safety committee in place would certainly be subject to their review in some way, shape, or form. Again, the Department of Labor has to issue guidance, or at least the statute requires them to issue guidance on these workplace safety committee issues. But when that happens and what it's going to look like is anybody's guess at this point. So putting all of that together, first of all, keep in mind that there's going to be more from the Department of Labor. This will probably include more on just the airborne infectious disease issue and the prevention plans. For example, they've already said specifically that model plans will soon be available in Spanish, and eventually it will be available in additional languages, at which point in time, if you have employees whose primary language is Spanish, for example, you will have to give them your airborne infectious disease exposure prevention plan in Spanish or whatever other language they speak, if there is a model plan available in that language. And of course, that means even if you choose to use an alternative plan rather than the model plan, you would then have to translate it in any language that there is a model plan available in. But hopefully there will also be additional guidance generally on how to use the plans and what's required and what some of the interpretations of different nuances in the law itself mean. The Department of Labor website on the HERO Act right now does say the Department of Labor will be sharing more details about this law in the near future. Please check this website for updates. So there is the link, or you can just go to Google and type in New York HERO Act, and you will most likely get the Department of Labor's page up first. Whether they mean more guidance on the airborne infectious disease exposure prevention plans, or they are alluding to the Workplace Safety Committee issue, is not clear, but I expect we will get more on both. So what do you need to do now? You certainly need to prepare for August 5th, meaning you better know how you're going to get a plan in place, or if you're in the healthcare industry, for example, are you going to take the position that you don't need to or shouldn't put a plan in place? I would generally recommend not moving faster than you need to in the sense of formally adopting a new plan, because it is possible, in my mind, that in the next couple of weeks, we will get more information from the Department of Labor that might in some way clarify or explain or change our understanding of what employers should be doing with those plans. But if there's nothing further, then the overwhelming majority of you better have a plan in place by August 5th, or else you're risking violation of the statute. I just asked the question, is there any reason not to use the model plans? I think there's a lot to be said for using them, especially for now. If you need to later, you could always adopt a new plan, subject to the risk of having to deal with your Workplace Safety Committee. But for now, there's an argument that if you just use the model plan and fill in the blanks, then you don't need to go to a union or any group of employees to get their meaningful participation. Not to say that you're opposed to having employee participation, but given the timeline, it's not clear that you could accomplish that, and specifically accomplish getting a union to agree to something. Now, that is to say, avoid the union might be an option by putting in place one of the template plans, but perhaps you already have something negotiated with the union, or have language in a collective bargaining agreement that would make it clear that you, for whatever reason, would have to negotiate this type of plan before you put it in place. Or you may just have a union say that we want to negotiate this, whether the implementation of the plan itself, or theoretically the impact or effects of the plan. Some of those union issues could get case specific, so I can't address them all here, but there's at least a general argument that the law itself suggests you can adopt one of these plans without involving your union in doing so. And keep in mind that the plan is not even going to be active as of August 5th, barring a designation of an infectious disease outbreak between now and then. So in that sense, it's somewhat an academic exercise for the immediate future. You can always revise the plan later, and you may have to. If the standards change, then you likely would be required to change your plan to comply with it. If you have a Workplace Safety Committee come into being and the guidance allows for it, they may have the right to go back and review the plan, theoretically to demand an alternative plan or a more detailed plan, etc. Jury is still out on that one. And then there is the training question. We know you'll have to do training if you ever activate your plan. That training is for all employees, except it does exclude independent contractors, notwithstanding the fact they're covered by the plans. So that's a slight break on that if you have to do the training. But again, open question that may or may not be answered in the next couple of weeks or thereafter by the Department of Labor is whether you have to do general training even before there's ever an outbreak and activation of the plan. If you have other training coming up anyway, if you can tie it in with your sexual harassment training that you have to do annually in New York, then perhaps it's better just to check off the box and give this plan out then and tell everybody what it's about and what the law says and things like that. But again, we don't have any more guidance. We don't know for sure whether the Department of Labor is going to put out model training on these issues or not, although that's certainly a possibility, as they did, of course, with the sexual harassment training. So obviously there's a lot of reason to stay up to date on this. You can check our LinkedIn page, Horton Law on LinkedIn, for the most recent updates. We'll also post articles on our blog, but sometimes that takes a little longer. That's on the website. And there will certainly be more webinars on the HERO Act as we get more from the Department of Labor, which will certainly be the case hopefully by November 1st with respect to workplace safety committees, but could yet also be the case even regarding the airborne infectious disease exposure prevention plans. Now I'm going to go to question and answer. While I'm giving you a minute to type in any more questions, I will also post the link to the slides for anyone who wants that now. Again, remember, if you are registered, then you will get an email tomorrow with the slides. It will also have a link to the recording of this webinar if there's anything that you want to watch again that you might have missed. If you have questions that are too specific to your company to ask in this situation, you can contact me. My contact information is on the screen. But now I'm going to go back and start trying to answer the questions that came in. And as I said, I will stay on until I answer all the questions to the extent that I have an answer. And if at any point I'm wrapping up and you have a question, then you can type that in or type in, wait, I have a question, and then type in your question. Okay, one question. There's a question that says, what is the point of having a model notice if there's no industry specific model and the Commissioner of Health has not designated an airborne infectious disease? I think that question would best be asked of the New York legislature. We're doing all of this because the law says we have to, which I think is the only reason the Department of Labor is doing this. I think it's fair to question how seriously the Department of Labor is taking these prevention plans. Not that they disagree with the concept generally, but they realize the frustrating reality that your question alludes to, that we're trying to write a plan to deal with some future disease that nobody knows what it's going to look like. And it's basically just a list of a bunch of, generic things that arguably were a good idea during the COVID-19 pandemic and may or may not have been and may or may not be in the future. As far as what industries there's a specific plan for, again, that was up to the Department of Labor. And frankly, the specific industry plans are not much more specific than the general plan anyway. So again, it looks more than anything like they're just checking off the box because the law itself specifically required them to come up with some specific industry plans. You can make an argument that the Department of Labor's model plans don't comply with the statutory mandate, but I don't really see much value in going down that road at this point. Yeah, there's a question that I think I might have alluded to. Assuming most will adopt one of the Department of Labor standard plans, are you able to adopt a more company-centric plan later on? And as far as I know, the answer to that is yes. There's nothing seemingly stopping you from revising your plan later, subject to dealing with any unions or getting employee participation, which you may have to do in light of a workplace safety committee anyway. So again, arguably, you could be forced to revise the plan later. The Department of Labor come out with an entirely different approach. There's nothing stopping them from changing their standards. And that might be generally, or might be in response to a specific disease that comes out in the future. So, yeah, I mean, I think there's merit to that approach of just adopting what you have to now and then thinking about whether you need to do something later. There's a question of whether there's a model plan for the performing arts industry. I think the point that to address here is I showed you which industries there are model plans for at this point in time. You could continue to check that New York State HERO Act website from the Department of Labor and see if they post new industry templates. There's nothing stopping them from doing so, nor nothing specifically requiring them to. But the key takeaway is there are many fewer industry templates for this requirement than there were industry specific guidance documents for COVID-19 in particular. So just because you might have been used to dealing with an industry specific document during COVID doesn't mean that there is now or will be a specific industry template for the Airborne Infectious Disease Exposure Prevention Plan obligation. Here's a question that says, if my business has all employees in New York that work from home and do not plan on returning to an office setting, do I still need to comply with the HERO Act? If you have no control over the employee's home work site, which in many cases would be true, then it's not a work site that you have to cover with a safety plan. So in that sense, you may not have to comply. If there's no corporate office or whatever where any employee works at all, then I suppose arguably you don't have to have a plan in place. I think my general recommendation would probably be to adopt a general plan and at least use it as support for the fact that everybody works from home anyway. So there's really nothing to worry about. But if at some future point in time there is a work site, then here's how we would address it. Because theoretically, you could rent an office for meetings or something like that that would then arguably become a work site. So I think that's how I would address that. As far as more broadly, remember the HERO Act also covers the workplace safety committees. Do you have to have a workplace safety committee even if you don't have any employees who work in a work site? I have a guess at what the answer to that might be, but again, I'd rather wait and see if the Department of Labor says anything further, and we'll talk about those types of issues closer to the effective date of that component of the law. If my business is located outside of New York, but I have employees in New York, do I still need to comply? And if that relates to the previous question, the issue is, do you have employees at a work site in New York? If they're just working from home, then arguably it's not a work site under the law, and you might not have to address it in a plan. But if there is or could be a work site within New York that those employees work at, then it would be subject to the requirement. And the fact that your company might be headquartered outside of New York does not mean that you don't have to comply with the law. So if, for example, you did have an office or you rent space even on a temporary basis where your employees are going to be working in New York State, then that would become a work site subject to your control that you need to have covered by one of these plans. There's a question about the first part of the plan where you're supposed to put in who's responsible for ensuring compliance with the plan, where it's the question says, is it acceptable just to find the titles of the person who will be the point of contact, or are specific names and telephone numbers needed to be included in the plan. I am just scrolling back into the statute itself, which says that it's required that you have designation of one or more supervisory employees to enforce compliance. So, I mean, it talks about one or more supervisory employees. There's no further guidance to say for sure whether you have to identify a specific person. I think you'd be better off having at least some contact information. If it's, your responsible person is the vice president for human resources, for example, and you could provide an email address that says something like HR at name of the company. That's always going to go to the vice president of human resources. That might be sufficient. If it's somebody else, safety director, and you can have an email account that says, workplace safety at name of the company, that might be sufficient. But if possible, I think the preference would be to identify one or more specific people and then change the plan as necessary if those people change. This question, what if our business doesn't own the property that it's working out of? Would you need to put in the engineering control section? Yes. I mean, you have to have that section in your plan. It seems well, I mean, you don't have to call it engineering controls, I should say, but you are required to address the issues in the standard. And the standard doesn't list engineering controls, but has certain other requirements about cleaning, disinfection, personal protective equipment, etc. So you would have some leeway if you're not using the model plan. If you're using the model plan, though, I don't think you can just take out the engineering controls. If you took that out, then you would be using an alternative plan, albeit based on the model plan, which would require you to either deal with the union or meaningful participation of the employees. All that being said, this says recommend writing contact property manager to ensure ventilation system is being maintained effectively according to CDC, OSHA. I mean, there's no guidance really as to what you have to do other than address it. So I don't see any reason you couldn't put that in if that's how it works. I mean, certainly you're not expected to change the ventilation system on your own in a building that you don't own. And again, the model plans are only written in a way to say, here are some examples of what you might do. So there's no specific requirement that you do anything with ventilation. What if I have employees where their corporate office is in New York, but the majority of the employees work in New Jersey? Do they still need to implement this act? Well, the corporate office in New York is subject to this requirement. So that's a work site in and of itself and would have to be covered by one of these plans. The employees working in New Jersey would be outside the scope of the New York State requirement. This only addresses work sites located in New York State, but the corporate office itself would qualify as a work site in New York. So you would just, if you're using the model plan, for example, fill in that first section that the plan applies to all employees of the company, in the following work sites, and then list the address of the corporate office, presumably. Not say you couldn't expand it to encompass New Jersey if you wanted to, but barring New Jersey law saying something different, there wouldn't be any obligation to do that. And the plan itself, if you use the model plan, refers to New York law and the New York HERO Act, and you would want to be careful to not somehow create some obligation to be bound by New York law with respect to New Jersey employees where that obligation otherwise shouldn't exist. What advice can you provide employers in a non-healthcare setting about how OSHA COVID guidance is affected by the New York State HERO Act? Which one should an employer follow? Well, outside of the healthcare setting, the OSHA guidance is really only that, basically in the same way that CDC guidance is really only that guidance. It's not obligatory that employers follow it. The New York State HERO Act, you have to remember, while it arose in the wake of the COVID pandemic, is not a COVID specific piece of legislation. At this point in time, there's no designation of COVID being a qualifying outbreak that requires activation of these plans. So these plans really are just a precautionary, preventative, we're ready in the case of some future outbreak of some airborne infectious disease. They really are not COVID specific. For now, to the extent you're following OSHA guidance or CDC guidance with respect to COVID, then there's nothing stopping you from doing so. If OSHA required something, if there were a standard in place, temporary, permanent, or otherwise, that was applicable at any point in the time now or in case of some future disease outbreak, then the way this is written from the Department of Labor, you would then have to follow that, notwithstanding anything in your New York State plan. But the New York State requirement right now is to have one of these plans in place. And that's about it. The plan's supposed to address various things. But again, there's no specific requirements from the New York State plan that says you have to do anything with respect to COVID or with respect to anything else other than have a plan. Recognizing that plan is going to depend a lot on whatever the future disease declaration is. Does including the plan in a handbook supersede the need to give a copy to new hires because all employees and new hires are given copies of the handbook? I mean, I think the answer to this basically is yes, assuming everybody is given a copy of the handbook. So assuming you have a handbook and you adopt a plan, you're going to then put the plan in the handbook because you have to. You then just need to make sure you give that new handbook with the new plan in it to employees within 30 days of adopting the plan. If you're not able to reissue the full handbook within those 30 days, I would at least get the plan out to employees. As far as new hires, assuming when they're hired, they're given a copy of the handbook that has the plan in it. I think you've satisfied that requirement. If you don't have a handbook or, again, haven't yet incorporated the plan into the handbook, then you would need to provide it to them otherwise in writing. There's a question about using a daily health screening questionnaire. Does that satisfy the screening for symptoms of the beginning of the shift? Specifically, what the model plan says is employees will be screened for symptoms of the infectious disease at the beginning of their shift. And then employees have to self-monitor thereafter. There's really nothing in the model plan. There's no blank or check off or anything else where you're expected to go into any further detail of how you're going to screen for it at the beginning of their shift. And again, I think how you're going to do that would depend on the circumstances of some future disease. Now, if COVID comes back to the point where the Commissioner of Health declares an outbreak that activates this plan, then certainly the daily health screening questionnaire that we've used under the pandemic in the past seems like a logical screening mechanism. Temperature checks may or may not have been a logical screening mechanism that were required in some cases. They may or may not be a valid screening mechanism for some future disease. Theoretically, there could be visual inspection if some future disease always is accompanied by, for example, a rash on the face or forehead or something. So again, the way these standards are written, the Department of Labor doesn't seem to be expecting you to go into detail into what your screening mechanism is going to be. It just requires a statement that you will conduct some sort of screening. The question says, will the safety committee guidelines be included in the model plan, which is effective August 5th and effective November 21st? I'm not really sure what that question is getting at, other than to say at this point, I wouldn't anticipate the Department of Labor to change anything in these model plans between now and August 5th. They may add more industry specific plans. They may provide some additional guidance and understanding, instructions, whatever you want to call it, about the plans themselves. Whatever is going to happen for safety committees will come out hopefully sometime between now and November 1st, and may or may not somehow address these airborne infectious disease prevention plans. But it's critical to keep in mind that, legally speaking, other than the fact they both came in the HERO Act, the Workplace Safety Committee is a totally separate legal obligation, distinct from this airborne infectious disease exposure prevention plan. Here's a question for the safety committee. When an employer has multiple sites, can the committee be one committee with representation from all locations? That is a question that is likely to be further explained by the Department of Labor sometime between now and November 1st. The statute itself, however, as amended, and this is a specific amendment in June, says that there will be not more than one committee per work site. So it is arguable, at least, that there could be a separate workplace safety committee at each work site. But there's reason to believe we need more guidance on how those are going to work before we can conclusively know what to do in that scenario. How does a plan work out for a group of employees that travel as a group to other venues? If they're using company vehicles that are controlled by the company, then those are work sites and need to be, in essence, covered by your plan. The extent to what can be done in a vehicle is different. When they get on site, on location, assuming that location is not controlled by the company, if, for example, they're at a convention putting on a trade show with a table or something like that, then it's probably not going to be the case that the plan needs to cover that type of work site. But if they are taking a company vehicle, like a bus or something, to go on site for whatever work purpose, then the bus itself is a work site. All right, I think I have answered all the questions that I have seen come in. If you have any more questions, there's still a good number of you on. Go ahead and type it in now, or type something to let me know you're working on your question. I'll give a little bit of time, 30 seconds or so, to see if anything pops up. Otherwise, thanks for all the great questions. To the extent I didn't have complete answers, again, hopefully we'll get more guidance from the Department of Labor. And, in some sense, unfortunately, this is just something that the legislature has thrust out there that everybody has to comply with. And I think the Department of Labor has done what they could to get these plans in place with, understandable obstacles against even them. Delivery trucks are part of the work site if they are within your control. The caveat on that is that delivery services are potentially subject to this as an employee, even though they're independent contractors. But if you don't have control over the vehicle, then there's not much you're going to be able to do to maintain that. Here's another question. Can you clarify again whether training should be completed when the plan is rolled out on 8/5 or not? The basic answer to that question is no. I cannot really clarify. It is not clear. That you could debate it either way without further guidance from the Department of Labor. The statute does not seem to require training until a plan is activated, meaning there is a designation by the Commissioner of Health of an outbreak of an airborne infectious disease that threatens the public health. But the model plans themselves contain language suggesting that employees will be trained even before there is an activation of the plan. So if you adopt the model plan, there's an argument that your plan now says you're going to provide training on the plan even before there's an activation of the plan, even though the statute doesn't seem to require it, and the standard per se adopted by the Department of Labor doesn't seem to require it. So it's really not a question of violating the statute or the standard at that point. It's a matter of, if you've adopted the state's plan, does your plan now say you're going to immediately provide training? And if you do, how immediate does that have to be? There's no guidance on that. Question about staff working under a contract at a location that is not controlled by the employer. For example, crisis staff working at a hospital. It has to be a location over which you as the employer have the ability to exercise control, or else it's not your work site. Not to say certain aspects of your plan shouldn't apply. I mean, you may need to provide these employees a face mask to take with them, for example. That would be easy enough, but you certainly can't be expected to have any control over the ventilation at the hospital, much less, whether they're doing screening of employees before they, or of the general public before they walk into the hospital or anything like that. So no, the statute itself is clear and has been amended to be clear that a work site is any physical space, including a vehicle, that has been designated as the location where work is performed, over which an employer has the ability to exercise control. And to go back to an earlier question, it goes on to say the term shall not include a telecommuting or telework site unless the employer has the ability to exercise control of such site. But if, for example, you rented an apartment for an employee and there was the expectation that not only would they live there, but also work from there, then that would constitute a work site over which you probably exercise sufficient control that you're obligated to comply with your plan with respect to that work site. All right, again, I'll wait just a little bit longer, see if any more questions come in. Again, if not, thanks for joining me. You will get an email tomorrow that will also have the link to the slides in case you didn't want to click on that yet. And we'll have a link to the recording of this webinar if you want to review it again. And as long as you have signed up for this and don't opt out of our email list, you will get a notification of future webinars, including the anticipated HERO Act Update Part 2, which may potentially be an extension of the airborne infectious disease prevention issues, or could jump us into the Workplace Safety Committee issue, depending on what the Department of Labor does next on this topic. With that, I'm going to go ahead and sign off, seeing no more questions, and look forward to seeing you all next time. Thank you.